Hello to America and hello to the world. Welcome to episode 2 of Barbara Stone Live. This is a show that speaks truth to the tyranny of the U.S. government. This platform is not intended to express my personal opinions. It is intended to describe the facts and the law. I head up a group of hundreds of victims all over the country of government crimes. I am a personal victim myself of the barbaric acts that I will be discussing. It is for this reason that I have declared my candidacy as the People's President in 2024. I am a former attorney who is an expert on and a whistleblower to the government corruption. My platform is to reclaim, secure, and protect the unalienable rights of we the people that are being deliberately and systemically deprived by the government. It is to make the public aware that there is no remedy to these crimes by the government itself, as all branches of government act in collusion. It is to wake up America to the fact that these are the most severe crimes possible and are known as atrocity crimes under international law. It is to make the public aware that it is only we the people who can remedy these crimes, that remedy is only possible when we the people understand the monumental depravity of these crimes and we the people act in unison to reclaim their rights. You can learn more about me and my platform on my website called peoplesrightsforum.com and in episode 2. The public needs to understand the obvious. The government will not self-correct its multi-trillion-dollar crime syndicate of human profiteering by depriving its population of their unalienable rights to strip them of their assets, their family, their liberty, and their lives. This is the very essence of slavery and human trafficking. This is a statement by the U.S. Supreme Court of Criminals in 1886 before they went completely rogue that succinctly explains the assertion that of the will of one human being over another is the very essence of slavery. Quote, the very idea that one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another is intolerable under any country where freedom prevails, as being the very essence of slavery itself. The citation is Yick Wu versus Hopkins, 118 U.S. 356, 1886. In this show, episode 2, we will discuss 1. What are our unalienable rights? 2. How we have no legitimate constitutionally created law enforcement, so there is no fix or remedy on the federal level. Number 3. Why there is no remedy on the state level, even though there are constitutionally created state law enforcement employees called sheriffs. Number 4. Some of the flaws in the Constitution that create these issues. And number 5. Why we the people ourselves hold remedy in our own hands and how this can be done. I urge everyone to watch episode 1 that summarizes how the U.S. wages war on the American and the world population by stripping, stealing, and depriving the public of their unalienable rights. All of the atrocity crimes being perpetrated by our government originate from the theft of our unalienable rights. Everyone is responsible to understand this simple, diabolical concept that is the crux of the U.S. war on humanity. This is the most important matter in the world. This is a summary of episode 1. Episode 1 explains that our unalienable rights are our most precious, valuable, and important possessions. Our unalienable rights are not constitutional or civil rights. They are our birthrights, and we own them. They exist because we exist as living, breathing human beings and are inherent by our human dignity. This is affirmed in the U.S. Declaration of Independence and the UN International Declaration of Human Rights. Our rights exist under natural laws, not man-made doctrines, so they cannot be legislated or adjudicated using man-made laws. Even the man-made Constitution itself limits and restricts the power and authority of the legislative employees to only those enumerated in Article 1, Section 8, which are limited to 8 matters dealing with commerce, debts, taxes, and certain crimes. Of course, there is no enumerated power to legislate or regulate our unalienable rights, as that is the very essence of slavery. The government exists for the primary purpose of upholding and protecting our unalienable rights. But instead, it deceives the public to believe that their rights are constitutional or civil rights in order to strip our rights using their void, unlawful, man-made laws and courts to steal our assets, our families, our liberty, and our lives. I call these void, null laws and courts Nuremberg laws and Nuremberg courts. When a government does not perform its function of protecting our rights, it is illegitimate and operates under color of law. It is up to we the people to reclaim and secure our rights using lawful means, including people's grand juries that I will discuss shortly. Once you begin to understand these incontrovertible facts, you will understand that we are in a terrifying U.S. war against humanity, a U.S. Holocaust. You will also see that the only path to remedy lies with the public, with we the people, that to continue to waste time, energy, and resources to plead to the illegitimate color of law U.S. government employees to self-correct their single-minded, highly profitable human trafficking, pillaging, and money laundering crime syndicate is the very definition of insanity. This is a huge wake-up call to the public to comply with their personal and civic duty to protect and secure their own unalienable rights, those of their families, and their community by uniting and holding we the people grand juries to hold the government employee perpetrators criminally and civilly liable. It is apparent that the government crime syndicate exists because the public does not understand their unalienable rights, that the government cannot regulate or adjudicate their rights, and that it is up to the people to protect their rights. Many have a vague concept that our unalienable rights are solely those enumerated in the Declaration of Independence as life, liberty, and the pursuit of happiness. These are cited as examples only and not intended to be comprehensive. Our rights extend far beyond these measly 3 rights enumerated in the Declaration of Independence, written in 1776, almost 250 years ago, in a slavery-driven economy. We have a bounty of almost 30 unalienable rights that are now specifically enumerated in the United Nations International Declaration of Human Rights, enacted in 1948. The UN Declaration of Human Rights resulted from the Second World War, which showed that governments that had no regard for the rights of their citizens ultimately had no reservations about immersing the world into a terrible conflict for their own twisted aims. However, the multi-trillions of taxpayer dollars plowed into the UN and the resulting UN declaration did not result in remedy to barbaric human rights abuse in the U.S. and elsewhere, as is mandated by its charter. This is because it is a farcical homage to lip service, as it has no independent military enforcement, and it is hypocritical as the UN is hosted by the United States. Notwithstanding the UN failure to uphold, secure, and enforce our unalienable rights, the UN Declaration of Human Rights is invaluable as it makes our unalienable rights abundantly clear. However, the failure of the UN or the US to protect our rights makes it all the more incumbent on we the people to lawfully secure our rights. We are in the year 2023, and the US government is perpetrating even worse barbaric crimes against humanity than in the medieval Dark Ages and certainly in the year 1776. And we the people have enabled these atrocity crimes by failing to protect our own lives, liberty, and family. We the people need to wake up. We need to move forward from the archaic colonial mentality and embrace the next millennium and the international laws that recognize and affirm that we have a powerful host of unalienable rights under natural laws that are articulated in the UN Declaration of Human Rights. Paragraph 16 of the UN Declaration specifically articulates our familiar rights that include our parental rights and our unalienable rights. It states, "The family is the natural and fundamental unit of society and is entitled to protection by society and the state." Other rights enumerated in the UN Declaration include the right to housing, education, privacy, ownership of property, equal access to public service, right to Social Security, social and cultural rights, the right to work, the right to social services, the right to participate in cultural life and the arts, and to share in scientific advances and its benefits, among a whole host of rights. Article 30 of the UN Declaration makes the following powerful statement: "Human rights cannot be taken away. Nothing in this declaration may be interpreted as applying for any state, group, or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms set forth herein." The people's common law grand jury is an unalienable right inherent under natural law to protect our fundamental right to life, liberty, and property. It is historically affirmed in the Magna Carta, created in the year 1215 to protect the rights of the people. It is a fundamental right in the U.S. Bill of Rights and the UN International Declaration of Human Rights. It is specifically affirmed in the Fifth Amendment as to criminal matters and the Ninth Amendment as to civil matters. The Fifth Amendment provides that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Article 9 preserves the right of trial by jury where the value in controversy exceeds $20 and states no fact tried by a jury shall be otherwise re-examined in any court than according to the rule of common law. It is specifically enumerated in paragraph 8 of the UN Declaration of Human Rights that provides everyone has the right to remedy, and in paragraph 21 and 29 that provide everyone has the right to take part in the government, the right of equal access to public service, that everyone has duties to the community, and that in the exercise of their rights and freedom, everyone shall be subject only to limitations that respect the rights and freedoms of others and of morality, public order, and general welfare in a democratic society. The U.S. Supreme Court of Criminals specifically affirmed in the case of U.S. v. Williams, 504 U.S. 36 in 1992, that the grand jury belongs to the people. This is the language by judicial employee Scalia in that case. Rooted in long centuries of Anglo-American history, and he cites Hannah v. Larch, 363 U.S. 4 20 in 1960. The grand jury is mentioned in the Bill of Rights. It has not been textually assigned, therefore, to any other branches described in the first 3 articles. It is a constitutional fixture in its own right. In fact, the whole theory of its function is that it belongs to no branch of institutional government, serving as a kind of buffer or referee between the government and the people. Scalia cites many other supportive cases throughout his statement. Nowhere in the Constitution do government employees have the power or authority to legislate our unalienable rights. To the contrary, governments are established to protect and secure our unalienable rights. There is no remedy to these crimes at a federal level because there is no lawful federal law enforcement. This is one of the government's biggest and best kept, mind-boggling secrets. Nowhere in the Constitution has any federal law enforcement agency been empowered or authorized. The federal government has created a fictitious charade that federal agencies with alphabet soup euphemisms such as the FBI, the DOJ, or the Secret Service are lawful and have law enforcement power and authority. These fraudulent agencies are not established under the Constitution. They are established under the codes and statutes of their fellow federal government employees. Not only do the alphabet soup federal agencies function as the protection arm to their corporate bosses, they themselves perpetrate countless crime syndicates. A whistleblower to the Department of Health and Human Services recently testified at a so-called, quote, Senate hearing to inform the dysfunctional conspirator legislative employees about how HHS is trafficking immigrant children at the border. Some of you may recall an expose of the FBI who used their position to raid a vault company where the public stored their valuables. The FBI simply opened up the vault and stole the possessions of the public that were stored in the vault. These crimes fall within the definition of domestic terrorism under 18 U.S.C. 2331. Many listening to this presentation have no doubt repeatedly gone to the federal alphabet soup terrorist agencies called the FBI and the DOJ to demand the arrest of the government employees who have kidnapped their children in the child trafficking racket or captured other family members in their murder-for-hire racket they call guardianship. Murder for hire is a crime under 18 U.S.C. 1958, and the guardian racket falls squarely within that crime. No doubt you are ignored or told these imposter government employees have no jurisdiction, or you are threatened. And now you know why. These alphabet soup terrorist agencies have no legitimate jurisdiction. They are conspirators and concealers to the deprivation of your rights. They are perpetrating their own schemes to defraud and committing honest services fraud by stealing taxpayer funds and using them to fund their terror war against the public. These are federal felonies under their own criminal laws, most of which are listed in Section 18 of their man-made code, which everyone should become familiar with. Thus, when you go to these color of law government agencies to report crimes of their fellow government employees, you are reporting the crimes of their bosses. It is the height of insanity to expect remedy. To the contrary, you are putting yourselves further in the line of fire to be subjected to retaliation. Moreover, you are giving them ammunition to close their loopholes by more illegal, unlawful, void, so-called laws. It is also questionable if federal legislative employees can even enact criminal laws that are not specifically related to their, quote, crime-fighting duties under Article 1, Section 8. Aside from touching briefly on treason, nowhere in the Constitution is any federal power given to deal with any other crime. Crimes, the laws created to prevent them, and its punishment were left to the individual states to handle. Alexander Hamilton acknowledged this in Federalist Paper No. 17 in 1787, where he said, "There is one transcendent advantage belonging to the province of state governments. I mean the ordinary administration of criminal and civil justice." So we have the ultimate irony that is the very essence of tyranny and domestic terrorism. Number one, the government employees are illegally and unlawfully using their position to concoct barbaric, Dark Ages, right-stripping laws to deprive our unalienable rights and enslave us. They are using their position to devise a vast collection of federal criminal laws whose legitimacy is questionable, to use them as weapons against we the people by federal law enforcement agencies and employees who have no jurisdiction or authority. It is those questionable laws that should bind the government perpetrators and hold them criminally liable, but we the people are unable to have those criminal laws enforced against government perpetrators because we have no legitimate federal law enforcement agencies. This is also glaringly apparent on the state level. On the state level, most, if not all, state constitutions create the position of sheriff, as they have the appearance of lawful authority and jurisdiction. However, it is a fact that most sheriffs function as the protection arm for the state actors, as their paycheck depends on their complicity. But even if a sheriff complies with their mandate and files criminal charges against a government perpetrator, the fraudulent so-called legal system is intentionally set up so that the official who can prosecute criminal charges is the state attorney, another government employee. But it is the state attorney who represents their federal corporate government employees to conceal and cover up their crimes when civil lawsuits are filed against them, so the likelihood that the state attorney will bring criminal charges against a government perpetrator is non-existent. So too, many of the judicial employees are appointed by their federal government employee, the governor, not elected by we the people. So what do you think is going to happen when you sue the governor employee for his crimes against humanity when the judicial government employees have been appointed by the perpetrator you are suing? Moreover, the color of law governor employees have locked in their own law enforcement protection arm, as they have created their own jurisdictionless law enforcement agencies to carry out personal vendettas and threaten whistleblowers and their opposition. So where does that leave us? It makes crystal clear that it is incumbent on we the people, and that we are responsible to act in unison to secure and protect our own unalienable rights by lawful means, including people's grand jury. I want to talk briefly about the Constitution, as the public needs to understand how some of the inherent conflicts we have discussed arise from flaws in the Constitution. The flaws are factual and reported in historical records and by constitutional scholars, and are not my opinion. Describing constitutional imperfections is not unpatriotic. To the contrary, it is protective of the public. It is patriotic of American values. It demands legitimacy, affirmation, and enforcement of the people's unalienable rights and governance that does not violate them. It strips the pretense by government that unalienable rights are constitutional or civil rights granted by public servants in order to steal and strip them under color of law. It makes clear that unalienable rights are endowed by the Creator and exist by our birth and human dignity. When the Constitution was established, it was rooted in conflict. It was not the product of like-minded members of the public with the same agenda. In fact, it was not created by the everyday John and J.Q. public at all. These are some of the important facts about the Constitution. There were 70 constitutional delegates appointed, and only 55 attended the Constitutional Convention. Of the 55 delegates, it is reported that approximately half of them owned slaves, collectively owning over 1,400 slaves. Slavery was not abolished in the Constitution. There were only 13 signatories to the Constitution. The delegates themselves were government employees, not members of the public. It is reported that 34 of the 55 delegates were attorneys. All of the delegates were politicians. They held at least one public office. There were no women or minorities. Everyone at the convention was a white man. The meetings were not open to the public. They were held in complete secrecy. I will present a more in-depth discussion of the Constitution in a later episode, but I wanted to present these takeaways and briefly describe the major issues involved at the time of the Constitution. There were two main warring fractions during the time the Constitution was created. One was the Federalist and the other was the Anti-Federalist. Their dichotomy is fascinating, as the Federalist and the Anti-Federalist were at opposite ends of the spectrum, as was their composition. Their major disagreement was that the Federalists wanted the federal government to hold strong and central power under the Constitution, and the Anti-Federalists feared a strong central government would become powerful and abusive, that the presidency would become monarchical over time, and that they wanted the power to be in the states to preserve rights. As apparent from their beliefs, the Federalists were elitist, aristocratic land and slave owners and merchant bankers. The Anti-Federalists were laborers, farmers, and shop owners. Each fraction published a series of papers to promote and support their positions on the Constitution, called the Federalist Papers and the Anti-Federalist Papers. These papers are very insightful to understand the concerns and the flaws in the Constitution. Another takeaway I would like to bring up here is that the Federalists believed that the common American at the time was largely ignorant and incapable of making intelligent decisions when it came to running the country. Because most of the Federalists were very wealthy, they did not want the power of voting in the hands of the lower class and believed with great fervor that the elite should rule. This explains why an electoral college was devised to take the power of direct elections from we the people, and how many so-called appointments of government employees were made by other government employees and not by vote of we the people. Even Federalist Alexander Hamilton acknowledged in Federalist Paper 33 that, quote, if the federal government should overpass the just bounds of its authority and make a tyrannical use of its power, the people whose creature it is must appeal to the standards they have formed and take such measures to redress the injury done to the Constitution as the exigency may suggest, and prudence justify. The public must wake up and understand the government is making tyrannical use of its power, that the crimes are deliberate, systemic, and done in collusion and conspiracy by all branches of government, that the so-called system and legal system is working exactly as it is intended to function by the government, as a well-oiled human trafficking machine. As set forth in the Declaration of Independence, all of these acts are intolerable acts. They are, in fact, far worse than the intolerable acts in 1776. As acknowledged in the Declaration of Independence and by Alexander Hamilton, it is the responsibility of we the people for redress. We must claim, protect, and secure our unalienable rights and hold the government perpetrators criminally and civilly liable by lawful we the people's grand juries and other lawful means. I welcome any comments and encourage everyone to join our People's President 2024 platform and the People's Grand Jury. I can be reached at barbara@barbarastone.org. I look forward to hearing from you.